Good evening, ladies and gentlemen. My name is Tanika Stevenson, and I'm tuning in with you from the United Kingdom. I am co-founder of a constituted group called Liverpool Advocates for Windrush. The other co-founder is my colleague, Mr. Garrick Priog. We are a non-for-profit constituted group who believe in helping people of all walks of life, irrespective of where you are in the world. In 2018, the Windrush scandal broke in the UK, and the government, as a result of that scandal, promised to try to right the wrong. My fellow Guyanese, why is this important to you? How are you affected, or how does this affect you? The Windrush scheme applies to Commonwealth nations, and a lot of them are not aware of it. As a fellow Guyanese, and I've been helping people from 2019, a few months after the scandal broke, I've now in 2023 thought that I can do something to help Guyanese citizens, which will then, in effect, increase the take-up of the schemes. I know a lot of you are wondering right now, what is the Windrush scheme? What is it about? The Windrush scheme, or the name Windrush, came from the MV Empire ship that came to the UK in 1948 that docked at Tilbury docks after the Second World War. The United Kingdom, Britain, invited people from the Commonwealth, skilled laborers, nurses, and those type of people, engineers, to help rebuild England after the Second World War. Because we were all part of the CUKC, which is Citizens of the United Kingdom and Colonies, because we were colonized by the British Empire, we did not have to have a visa to come here. We were British, but by birth. We were entitled to all the rights as a British citizen had, even though we were not born here. The MV Empire Windrush ship docked at Tilbury in the UK the 21st of June 1948. The passengers, however, were only allowed to disembark on the 22nd of June 1948. Hence today, this year in 2023, 22nd of June, we celebrated 75 years of that ship docking. 75 years Windrush anniversary was celebrated. My aim today will give you the background, describing to you the schemes and how this applies to you, us Guyanese people, along with other Commonwealth countries, is so that you're aware that this is applicable to yourselves, how you can access the schemes as is at the moment. You may choose not to want to take up the schemes because you may not be eligible, but for those who are, please consider it. Please consider contacting us. Please consider applying. You have more to gain than to lose. As I've said earlier, 1948 is when the Windrush ship docked at Tilbury in London. I will read from the government website. Everything I'm about to say to you is public knowledge and can publicly be accessed. I'm not an immigration lawyer. I'm not giving you immigration advice. I'm merely an advocate for Windrush, and I assist people to complete their applications and submit them to the Home Office, the UK government, on their behalf. The government's UK side defines the Windrush schemes. The Windrush scheme are people who arrived in the UK many years ago and do not have documentation confirming their immigration status. And they have faced difficulties in proving their right to work, to rent property, and to access benefits and services to which they were entitled. The government has apologized to the people in this position and has made a commitment to help them to get documentations they need. Because most of the people applying to this scheme are overseas, including you, my Guyanese brothers and sisters, there are 4 subheadings that we need to be aware of, that you need to be aware of. Before going to those 4 subheadings, I need to make this clear that the Windrush schemes do not consider nor compensate you for discrimination nor racism that you may have experienced. I would like this message to get out to each and every person in Guyana and around the world Commonwealth citizens who may be affected, because it doesn't only affect people who would have came here between 1948 and 1989, the 1st of January, but it affects their children, their grandchildren. And they, in their own rights, may be able to apply to the schemes. A person in the UK, that's the first subcategory. A Commonwealth citizen who was either settled in the UK before 1st of January 1973 and has been continuously resident in the UK since their arrival, or has the right of abode. I will later explain what right of abode means. The second category, a Commonwealth citizen who was settled in the UK before 1st of January 1973, whose settled status lapsed because they left the UK for a period of more than 2 years, and who is now lawfully in the UK and has strong ties to the UK. A child of a Commonwealth citizen or parent where the child was born in the UK or arrived in the UK before the age of 18 and has been continuously resident in the UK since their birth or arrival, and the parent was settled before 1st of January 1973 or has the right of abode, or meet these criteria but is now a British citizen. And lastly, a person of any nationality whose arrival in the UK before 31st of December 1988 and is settled in the UK. Those are the 4 categories. The first 4 categories that I mentioned when I said there are 4, those are the 4 that are not specifically applicable to a lot of people who are outside of the UK. They are more for people who are inside. There is a 5th category, and this is a category that is applicable to most Commonwealth citizens who reside outside the UK. And this category is a Commonwealth citizen, which we are as Guyanese people, who was settled in the UK before 1st of January 1973, but who does not have a document confirming the right of abode, or whose settled status has lapsed because they left the UK for a period of more than 2 years. What is the meaning of Commonwealth citizens? Here, the document reads that has been issued by the UK government as a person who is eligible for consideration under the Windrush schemes. Now, this is really important because over the past few years, a lot of people have migrated to Guyana. Now, if your country is mentioned from the list of countries I'm about to read from the government's website, then you may be entitled to claim under the Windrush schemes. The Windrush schemes are there to, 1, rectify your immigration status, where you may be able to come and live in the UK permanently, free of charge, or claim compensation because you fall under the 10 heads of claims that the government has identified and you've had significant loss as a result. The minimum award is £10,000. On the government's website, it has the meaning of Commonwealth. Commonwealth citizens means citizens of the following: Anguilla, Antigua and Bermuda, Australia, Bangladesh, Barbados, Belize, Bermuda, Botswana, British Antarctic Territory, British Indian Ocean Territory, Brunei, Canada, Cayman Islands, Cyprus, excluding the sovereign base areas, Dominica, Falkland Islands, Fiji, Ghana, Gibraltar, Grenada, Guyana, Hong Kong, India, Jamaica, Kenya, Kiribati, Lesotho, Malawi, St. Kitts and Nevis, St. Vincent and the Grenadines, Swaziland, Tanzania, the Bahamas, the Gambia, Togo, Trinidad and Tobago, Malaysia, Maldives, Malta, Mauritius, Montserrat, Namibia, Nauru, New Zealand, Nigeria, Pakistan, Papua New Guinea, Pitcairn, Henderson, Duce and Ono Islands, St. Helena, Ascension and Tristan da Cunha, Turks and Caicos Islands, Tuvalu, Uganda, Vanuatu, Virgin Islands, Zambia, Zimbabwe, St. Lucia, Samoa, Seychelles, Sierra Leone, Singapore, Solomon Islands, South Africa, South Georgia and the South Sandwich Islands, and lastly, Sri Lanka. As I mentioned before, the Windrush schemes are consisted of two schemes. One, status rectification, and the second is the Windrush compensation scheme. I'm now going to speak to you about the Windrush status rectification scheme. Status rectification is where you're entitled to British citizenship through naturalization, but you were not naturalized for whatever reason, and it's proven that you're eligible, then you would be given this free of charge under the Windrush schemes. In order to claim compensation, you first have to have your status rectified. If you choose to maintain your citizenship of origin, so for example, if you choose to remain Guyanese and do not have dual citizenship, such as British citizenship and Guyanese citizenship, that is okay. If you were here during the periods I mentioned earlier and you were unable, this is very important, you were unable to prove that you were entitled to access services and provisions that are offered in the UK because you could not prove your lawful status to be here, then you may be eligible to claim under the Windrush schemes. The schemes, again, as I mentioned earlier, does not compensate for discrimination that you may have experienced, nor racism. I appreciate that during the period of 1948 to 31st of December 1988, you may have experienced hostility. However, the government's definition and their acceptance of the hostile environment as the government sees it is not as we know it to be. The government's position is that the hostile environment started in 2007, not before. They also acknowledge that the hostile environment was as a result of successive legislations that has been introduced, such as the 1971 enacted 1973 Immigration Act in the UK and onwards, that has caused and made it very difficult for people who would have came to the UK 1948 and onwards that did not need British status because they were citizens of the United Kingdom and colonies. They had a CUKC passport. They did not need to get a British passport as the people born here and got British passports. They did not need to do that because they were British, but by birth. However, legislation changed and that affected those people. They're known as the Windrush generation and descendant. And as a result, it became difficult for them to access healthcare, employment, benefits, and it should not have been. If you were one of those persons who found it particularly difficult during the period of 1948 to 31st of December 1988, or even onwards from that period, i.e. 1988 to 2023, which we're in now, to prove your status, or you were denied employment, benefits, because you could not prove that you had a right to be here and access such, then you may be eligible under the Windrush schemes. Please get in touch with us. We're here to help. And it's for free. Our number is accessible through WhatsApp. Please call us on WhatsApp. Send us an email. We're here to help. We are a not-for-profit organization. Any awards given to you by the UK government is yours. So if you apply to the Windrush scheme from overseas, this process is done online through the government website. As an overseas applicant, once you've completed your application, you will be invited to get your biometrics done. We can discuss that further when we reach that stage. The aim of this video is to create awareness, to encourage you to take up the scheme. Again, you cannot claim compensation until you've identified and established with the Home Office that you're eligible under the Windrush schemes. Even if you choose not to, even if you choose not to accept British citizenship, for example, like India, they're only allowed one nationality. They cannot have dual citizenship. So it's either you retain your Indian nationality or you have to give it up to become British. In Guyana, we're allowed dual citizenship. So you can be both British and Guyanese. If you choose to retain or obtain both, that is fine. Only once we've established that can you proceed to claim compensation if you're eligible. The losses that you would have had to suffer had to be significant in order to be considered. But that's where we come in. That's where I come in. My team and I will do our best to help you. If we cannot help you, we will signpost you and refer you to people who can help. The institutions and our strategic partners that can help. You are not alone. We are here to help, and for free. As someone very dear to me says, free is better than cheap. So please bear that in mind. I said earlier that I was going to come back and give you the definition of right of abode. And why right of abode is important is that you could have came to the UK 1980, for example, but you only came here to visit or on a student visa. Then you would not have had a right of abode. The reason why the hostile environment or even legislative changes took place, starting with a major legislation passed 1971, enacted in 1973, was because a lot of the Commonwealth countries gained their independence from the United Kingdom. And as a result of a lot of people becoming independent, choosing not to be colonized anymore, the UK government said, okay, you want your independence, that's fine, but you're not going to have the right as you had before to come to the UK and travel as you would as an ordinary British citizen. So the definition of right of abode, the right of abode in the UK is only conferred to British citizens and a limited number of citizens of Commonwealth countries. You will have the right of abode in the UK if by 31st of December 1982, you were a citizen with a parent who at the time of your birth or legal adoption was a citizen of the United Kingdom and colonies and obtained their citizenship by being born in the UK, or you were a citizen before 1st of January 1973 and you were married to a man with right of abode. Right of abode means you don't have any limitations or nothing that prohibits you being able to come and go from the UK as you wish. Right of abode is different from indefinite leave to remain and leave to enter. Leave to enter is permission that is given to a person traveling to the UK by an immigration entry clearance officer to enter and remain in the UK. You must have leave to enter if you're traveling to the UK and you are not a British citizen, an Irish citizen, or a Commonwealth citizen with right of abode in the UK. Only if you have right of abode can you go and come as you wish. Leave to enter differs again from indefinite leave to remain in the UK, because indefinite leave to remain means you do not have any time restrictions on how long you can stay in the UK. However, your right of abode, your indefinite leave to remain, could lapse. This is very important as it applies to Commonwealth citizens and people who live abroad. This lapses after 2 years of you being outside of the UK. Irrespective of the reason you choose to live or be outside the UK, if it's more than 2 years, and you had indefinite leave to remain, which meant that you could have lived and worked in the UK as you liked, it would have lapsed. That means if you try to come back to the UK after 2 years of being outside, then the immigration officer has a right to stop you and deny you entry. Prior to the 6th of July 2018, you had to verbally demonstrate to the immigration officer at the airport or upon entry that you were a returning resident and that you maintained strong ties in the UK. If that immigration officer refused you at the airport, then you were still allowed to come into the UK and make your appeal from within the UK. This is before the 6th of July 2018. After the 6th of July 2018, you were not allowed in the UK anymore. You had to go back to the country that you were coming from or country of residence and make an application from outside of the UK. So this is important. So if you had right of abode, you had indefinite leave to remain in the UK, and you left the UK for more than 2 years, you need to apply for an entry clearance visa before you return to the UK. And this is also under the Windrush schemes. I'm merely giving you the information that is of public access in immigration schemes, of public access in the Windrush schemes that lends itself to immigration law. But I'm not an immigration advisor, I'm not an immigration lawyer. I'm merely giving you the information that's within the Windrush schemes, and to help you navigate and understand the Windrush schemes so that you can make your application. As I've already stated, post 6th of July 2018, the evidential burden to re-enter the UK if you're ILR, indefinite leave to remain, your right of abode, which gives you the right to live and work here as you're a British citizen, but you just didn't have a passport or naturalized or registered as British, is higher. The evidential burden is now higher. It's harder. It's not impossible, but please be aware there's much more involved. What is strong ties, you may ask yourself? The Home Office defines strong ties as having a husband, a wife, children, other relatives, financial ties in the UK, businesses, friends, and so on. You would have to demonstrate that you maintained close and continuing contact with said people or your business, and that you had intention and have intention of making the UK your permanent home, your permanent resident. Again, this is important. It does not preclude you, it doesn't exclude you, it does not stop you or prevent you from applying to the schemes if you choose to live in Guyana. If you say, well, I want to live in Guyana because the sun is there. It's not cold as it is in the UK during winter months. That is fine. You can do that too. But you have to establish that you're eligible. And the reason why I'm reaching out to you Guyanese people, my fellow Guyanese people, because I'm also Guyanese, is that a lot of people do not know that they're eligible to apply to the schemes. They do not think that it applies to them, but it does. If you, your grandmother, your grandfather, anyone you know that you're close to came to the UK between the periods of 1948 and the 31st of December 1988, then you may be eligible to apply to the schemes. If when you came under Citizens of the United Kingdom and Colonies Passport, CUKC, if you are successful through the Windrush schemes, you will be given a returning residence visa. Upon return, you have to spend 5 years continually resident in the UK before you can apply for naturalization. Naturalization is where you become a British citizen. You go through the ceremony. You must again meet the returning residence criteria in order to be successful with your claim. And this is all part of the status rectification. Only then can you go on to apply to claim compensation. The Windrush Compensation Scheme is not a restitution scheme. It's not to put you in a position you would have been in had you not incurred the harm or the negative impact that you've suffered because you could not prove your right, or you could not prove that you had a right to access health treatment in the UK, for example, benefits, education, going to university, or whatever the case may be. I have here, as way of ease of reference for everyone, if you are to claim compensation, there are 10 heads of claims, as I've mentioned before, that you can claim under. The 10 heads of claims are employment, immigration fees, housing, health, education, driving license, banking, daily life. For example, you missed major family events or could not travel. You were in the UK or you're abroad, in this case Guyana. Somebody died in the UK, you wanted to attend their funeral, but you could not travel because your visa lapsed, i.e. your ILR, or you're a descendant of a Windrush generation whom you were close to, you could not get here. Again, each case is unique, each case is different, so please reach out and we will go through it with you. The next head of claim that you can claim under the compensation scheme, the Windrush Compensation Scheme, is detention and removal, living costs. For example, rent, utilities, contribution towards food and household essentials, travel and prescription fees. If you've suffered losses relating to your inability to prove that you had a right to be in the UK, then you may be able to claim under any of these 10 heads of claim. They are employment, immigration fees, housing, health, education, driving license, banking, daily life, detention and removal, and living costs. If you had to pay, for example, immigration fees to a lawyer, solicitor, or a barrister, wherever you are, in Guyana, it'll be a lawyer, to help you prove that you were eligible to come back or to be in the UK or just to apply for a visa under the Windrush schemes, or if you were eligible based on the dates, which I will recap in my conclusion, then you may be entitled to get the cost that you paid back. More importantly, one of the things I didn't cover or haven't covered as yet is under the Windrush schemes, there are 3 types of claims that you need to be aware of. There's a primary claimant, secondary claimant, and the deceased estate claims. The primary claimant is a person who's been affected, like for example, your grandmother, your grandfather, and they are the person making the claim, even you yourself. Irrespective of your age, once you've been affected, you can make a claim. The secondary claimant is a close family member or relative who has seen the impact on you, the primary claimant. They too can claim to the Windrush status and/or compensation schemes. And the third category of claims is a deceased estate claim. So if your grandmother, grandfather has passed, and you're aware that one, they came to the UK in 1965, for example, left 1972. They had ILR, indefinite leave to remain. They were British because their country did not gain independence until 1969, for example. In Guyana, in this case, 1966, when we gained our independence, your parents or grandparents came here in 1962, left the UK in 1970. They went back and they stayed in Guyana because they preferred the sun over the snow. You, as their descendant, their grandchild, their daughter, their son, their aunt, sister, brother, you may be entitled to claim on their behalf, even if they're dead. Once you can prove evidence, I will help you with obtaining the documents insofar as I can. Once you can evidence that they had suffered, i.e. could not prove or struggle to prove that they had a right to be here and could not access certain benefits, health, then they may be entitled to claim, or in this case, you on their behalf because they're dead, and that is called the deceased estate claims. Please do reach out. Please have a conversation with us. Remember, free is better than cheap. In conclusion, who can apply? If you came to the UK from a Commonwealth country before 1973, your parents or grandparents came to the UK from a Commonwealth country before 1973, you came to the UK from a country before 31st of December 1988, and you are now settled here in the UK. Also, if you're a close family member of someone eligible to claim and you have had significant losses yourself, I repeat that, you are a close family member of someone eligible to claim and you have had significant losses yourself. And lastly, representing the estate of someone who would have been eligible. So if my grandmother, grandfather had came to the UK and then they came back, and I have lots of cousins and stuff that I'm aware of, or my grandmother told me that came to the UK when I was younger. A lot of them I do not know, but they went back to Guyana. They may be entitled to claim. Unfortunately, this has not been publicized, in my opinion, enough. Please reach out to us. Please use us. We're here to help. If we can't help, we'll pass you on to those who can. Our organization is Liverpool Advocates for Windrush. We're here to help the people of Liverpool here in the United Kingdom, but also I'm Guyanese. I would like to help you, my fellow Guyanese, and anyone else who would like to access the Windrush compensation schemes. My team and I, we're here to help. And I work with solicitors. If the case falls outside of our remit, they're happy to take it on as immigration specialists. If the case warrants itself that the matter should be resolved in court, then we have strategic partners who are willing and able to advocate for legal aid on your behalf and take the matter to court, to represent you in court for free. So please do reach out, have a conversation. We are here to help. Thank you all for your time. Thank you for listening. Thank you for tuning in. It is much appreciated. Time is the most valuable asset we have. And most importantly, we look forward to working with you, to helping each and every one of you. We aim to get you what you deserve.